Welcome to Short Questions with Narayan. Today we will be discussing about constitutional law part 1. This is covering the very short answer type questions for the students of LLB, PLLB, BBALLB, LLM, those who are aspiring to appear in CLAT, ISLET exams, semester exams, UPSC state PCS and UGC-NET law exams and other law related competitions. So let's start from question number 1. There would be total 55 questions, most important very short answer type questions. Let's start. Define constitution. Constitution is a fundamental legal framework or a set of principles according to which a state is governed. It contains the distribution of powers, the structure of government, and the rights of individuals. Mention different types of constitutions. The two types of constitutions mainly are written constitution, a formally codified document. Examples are the US Constitution and the Indian Constitution. Unwritten constitution based on customs, traditions and judicial decisions, parliamentary resolutions. One of the example of unwritten constitution is of that United Kingdom Constitution. What was the significance of the Regulating Act of 1773? The Regulating Act of 1773 was the first step towards the British government's regulation of the East India Company's administration. It established a Governor General of India and created a Supreme Court in Calcutta, making the beginning of centralized control over India. What were the objectives of the Government of India Act of 1858? The Government of India Act of 1858 transferred the control of India from the East India Company to the British Crown. It aimed to centralize power and introduce the office of the Secretary of State for India and the Viceroy to represent the Crown in India. What did the Montagu-Chelmsford reforms of 1999 introduce? The Montagu-Chelmsford reforms introduced the concept of diarchy in provincial governments, where subjects were divided into reserved and transferred categories. It also led to the establishment of the legislative councils at both the central and provincial levels, giving Indians a greater role in governance. What was the significance of the Government of India Act of 1935? The Government of India Act of 1935 was a major step in the constitutional development of India. It provided for a federal structure, introduced provincial autonomy, and laid the foundation for a more representative government. It was a precursor to the eventual Indian independence and constitution making process. What is constitutionalism? Constitutionalism is the principle that the government derives its authority from a constitution and must operate within its limits. It ensures that power is exercised within a legal framework to safeguard individual rights. Mention any two features of the Indian Constitution. One is sovereign, socialist, secular, democratic republic. The preamble declares India's core political principles. Second is fundamental rights. It guarantees 6 categories of rights to protect individual freedom. Why is the Indian Constitution considered flexible and rigid? The Indian Constitution is flexible because it can be amended easily by a simple majority, and it is rigid due to the special procedures required for important amendments. It's mentioned in Article 368. What is a preamble? The preamble is the introductory statement of the Constitution that outlines its purpose, guiding principles, and objectives. What is the scope of the preamble? The preamble reflects the ideas and philosophy of the Constitution and serves as a guiding light for interpreting its provisions. What is the importance of the preamble of our Constitution? The preamble is important because it declares the source of authority, that is the people, sets the goals of justice, liberty, equality and fraternity. It defines India as a sovereign, socialist, secular and democratic republic. mention any two objectives of the preamble. The first is to secure justice of social, economic and political for all, to provide liberty of thought, expression, belief, faith and worship to all. What are the values enshrined in our preamble? The preamble enshrines values like justice, liberty, equality, fraternity, secularism and democracy. What what entities are included under the term state as per Article 12 of Indian Constitution? The state includes the government and parliament of India, the government and legislatures of each state, local or other authorities within India or under the control of the government of India. Are public sector undertakings, that is PSUs, considered a part of the state under Article 12? Yes, PSUs are considered part of the state if they are substantially controlled by the government. Example, ONGC, that is Oil and Natural Gas Corporation, LIC of India, that is Life Insurance Corporation of India, State Electricity Board. The Supreme Court has ruled that statutory corporations like these are considered state because they were created by a statute, have the power to make binding rules and regulations, they are subject to government control. What is this definition of state under Article 12 important? Why is the definition of state under article is important? It is important because fundamental rights can be enforced against entities defined as the state, ensuring accountability for violation of these fundamental rights. What is law under Article 13 of the Constitution? Under Article 13, law includes any ordinance, order, rule, regulation or bylaw made by the legislature as well as judicial decisions. It refers to any law that is made by a competent authority in the exercise of its powers. What does Article 13(2) of the Indian Constitution prohibit? Article 32 prohibits the enactment of any law by the state that takes away or abridges the fundamental rights guaranteed by Part 3 of the Indian Constitution. Any law inconsistent with these rights is void. What does Article 14 of the Indian Constitution guarantee? Article 14 guarantees equality before law and equal protection of law within the territory of India. Which article of the Indian Constitution encompasses the right to equality? The right to equality is encompassed in Article 14 to Article 18 of the Indian Constitution. Which article of the Indian Constitution covers the right to freedom? The right to freedom is covered under Article 19 to Article 22 of the Indian Constitution. What are the 6 freedoms guaranteed under Article 19(1) of the Indian Constitution? The freedoms are speech and expression, assembly, association, movement, residence and profession. Which article of the Indian Constitution provides protection in respect of conviction for offences? Article 20 of the Indian Constitution provides protection in respect of conviction for offences. What are the 3 protections guaranteed under Article 20? The 3 protections are protections against ex post facto laws, protection against double jeopardy, and protection against self-incrimination. You must know what is ex post facto. That means from a thing done afterward. It is a Latin word. Ex post facto laws means a law that retroactively punishes or penalizes someone for an offense or an action that was legal when it was committed. Retroactively means with effect from a date in the past before a law or before a decision. These are not important for exam point of view, those things which are mentioned in the bracket like ex post facto laws retroactively. But this, as a law student, you must know these things as you will cover this during your entire course period. Which article of the Indian Constitution guarantees the right to life and personal liberty? It is Article 21 of the Constitution that guarantees right to life and personal liberty. What does the term personal liberty under Article 21 include? Personal liberty under Article 21 includes the freedom to live with dignity, the right to privacy, and protection against arbitrary deprivation of life or personal freedom. Is the right to life under Article 21 absolute? No. The right to life under Article 21 is not absolute. It is subject to procedure established by law. What is absolute right? We must know. A right that is not subject to any limitations, restrictions or exceptions. It is unconditional and cannot be lawfully interfered with under any circumstances. Which article of the Indian Constitution guarantees the right to education? Article 21A of the Indian Constitution guarantees the right to education. What does Article 21A of the Indian Constitution provide? Article 21A provides free and compulsory education to all children aged 6 to 14 years as a fundamental right. Under which act was the right to education implemented? The right to education was implemented under the Right of Children to Free and Compulsory Education Act of 2009, that is known as Right to Education Act. Which article of the Indian Constitution deals with the right against exploitation? Articles 23 and 24 of the Indian Constitution deals with the right against exploitation. What does Article 23 of the Indian Constitution prohibit? It prohibits human trafficking, forced labor and other forms of exploitation. What is prohibited under Article 24 of the Indian Constitution? Article 24 prohibits the employment of children below the age of 14 years in factories, mines or other hazardous occupations. Which article protects the right of minorities to establish and administer educational institutions? Article 30 protects the right of minorities to establish and administer educational institutions of their choice. What are cultural and educational rights? Cultural and educational rights are fundamental rights guaranteed under Article 29 and Article 30 of the Indian Constitution. It allows minorities to preserve their culture, language and establish and manage educational institutions. What does Article 29(1) ensure? Article 29(1) ensures that any section of citizens having a distinct language, script or culture has the right to conserve the same. What is the right to constitutional remedies? The right to constitutional remedies under Article 32 of the Indian Constitution allows individuals to approach the Supreme Court or High Court under Article 226 to enforce their fundamental rights. Who said Article 32 is the heart and soul of the Indian Constitution? It was said by Dr. Bhimrao Ambedkar. In short, Dr. B.R. Ambedkar. What are the 5 writs issued under Article 32? The 5 writs are habeas corpus, mandamus, prohibition, certiorari and quo warranto. Can the right to constitutional remedies be suspended? Yes, the right to constitutional remedies can be suspended during a national emergency under Article 359. What happens if there is inconsistency between fundamental rights and laws implementing directive principles? Directive principles of state policy and fundamental rights complement each other, but in case of a conflict, fundamental rights will prevail. What did the 25th Amendment Act of 1971 introduce concerning directive principle and fundamental rights? The 25th Amendment Act of 1979 introduced Article 31C, giving precedence to laws implementing certain directive principles over fundamental rights under Article 14 and 19. Can all directive principles override fundamental rights? No. Only those directive principles related to Article 39B and Article 39C, focusing on equitable distribution of resources and preventing concentration of wealth, can override fundamental rights under Article 31C. What are directive principle of state policy? Directive principle of state policy, that is DPSP, enshrined in Article 36 to 51 of the Indian Constitution are guidelines for the government to establish a just society and achieve socio-economic goals. Are directive principles enforceable by courts? No. Directive principles are not enforceable by courts but are fundamental in governance and aim to guide policy making. They are not justiciable. DPSPs are not justiciable means they are not subject to trial in a court of law. Which part of the Indian Constitution contains the directive principles? Direct principles are contained in Part 4 of the Indian Constitution. Name any two directive principles mentioned in the Constitution. One is promotion of the welfare of the people, Article 38. Equal pay for equal work for both men and women, that is Article 39. What are fundamental duties? Fundamental duties listed in Article 51A of the Constitution are moral obligation for Indian citizens to promote harmony and strengthen the nation. Which constitutional amendment introduced fundamental duties? The 42nd Constitutional Amendment Act of 1976 introduced fundamental duties. How many fundamental duties are listed in Article 51A? In total, there are 11 fundamental rights listed in Article 51A. Are fundamental duties enforceable by law? No. Fundamental duties are not legally enforceable, but they serve as moral obligations for citizens. Name any two fundamental duties. One is to abide by the Constitution and respect its ideals and institutions. Second, to protect and improve the natural environment. Name the committee that recommended the inclusion of fundamental duties in the Constitution. It was the Swaran Singh Committee recommended the inclusion of fundamental duties. The committee's recommendations were approved and implemented in 1976 through the 42nd Constitutional Amendment Act. When was drafting of Indian Constitution ended and when was it enacted? The drafting ended on November 26, 1949, and it came into force on January 26, 1950, the day we celebrate the Republic Day of India. What is the purpose of Article 368 of the Indian Constitution? Article 368 provides the procedure for the amendment of the Constitution. It outlines how the Constitution can be amended by the Parliament, either by a simple majority or a special majority, depending on the nature of the amendment. What is the role of the President in the constitutional amendment process under Article 368? Under Article 368, the President's role is to give assent to the amendment bill passed by both houses of Parliament. The President does not have the power to withhold or amend the bill. How many types of amendments can be made under Article 368? There are three types. One is amendments requiring a simple majority in Parliament. Second, amendments requiring a special majority in Parliament. Amendments requiring a special majority in Parliament and ratification by at least half of the states. What is meant by ratification by states in the context of constitutional amendment? Ratification by states refers to the requirement that certain amendments as specified in Article 368 must be approved by at least half of the states in the country before they can become law. This applies to amendments related to the distribution of powers between the Union and the states. The last question, can the basic structure of the Indian Constitution be amended? No. The basic structure of the Constitution cannot be amended. The Supreme Court held this in the case of Kesavanand Bharati versus State of Kerala of 1973. It held that while Article 360 allows for amendments, any amendment that alters the basic structure of the Constitution is unconstitutional. With this, we comes to an end of this video of the very short answer type questions of the Constitutional Law Part 1. I hope you like the content of this channel. Please subscribe to my channel and hit the bell icon to get latest videos updated on subjects. Like it and share it. Your comment encourages me. Do comment to make it better. Good luck to you. Do well in your exams. Do well in your life. Thank you for watching me. Thank you once again.